because I know you got a lot of questions, and I want to answer your questions, and I want to talk to you.
And he was told specifically that he was not under arrest.
Before I do, I'm going to read you your Miranda rights. Have you ever been read your Miranda rights before?
So this occurred within 5 minutes
Okay, well, this.
of this dude showing up at the office. He says, yeah, I took the property. Next one is Oregon versus Mathiason. This case comes from...
Are you sure?
I'm pretty sure. I wanted to say Mathiason, but
it's
I'm pretty sure it's Mathiason.
all right.
Anyways, this case comes from 1977, so we fast forward 8 years. And this involves the arrest of Carl, probably Mathiason. That's his name. So he was convicted of first-degree burglary after a bench trial in which his confession was critical to the state's case. So an officer of the state police in Oregon was investigating a theft at a residence near Pendleton, Oregon. And he asked the lady of the house. That's all it says. Lady of the house.
The lady of the house.
The lady of the house, which had been burglarized, if she suspected anyone. And she said, well, Mathiason is the only person that I can think of. He's a parolee and a close associate of my son. So this officer tried to contact Mathiason on 3 or 4 occasions with no success. So about 25 days after this burglary happened, the officer leaves his card on Mathiason's apartment with a note asking him to call.
Call me, please.
Because, quote, I would like to discuss something with you.
Discuss something.
Believe it or not, the next day, Mathiason called him. And the officer was like, hey, dude, where would it be convenient for us to meet? Mathiason's like, I don't care, man. So the officer said, all right, well, why don't you meet us at the state patrol office in about an hour and a half, and we can talk there. And Mathiason says, cool. The patrol office was like 2 blocks from this guy's apartment.
Well, that's quite convenient.
Yeah, it worked out well. So the officer met Mathiason in the hallway, shook his hands, took him back into an office, and he was told specifically that he was not under arrest. The door was closed, and the two sat across the desk from each other. And their dispatch center was close, so the police radio in another room was able to be heard. And the officer told Mathiason he wanted to talk to him about a burglary, and that his truthfulness would possibly be considered by the district attorney or the judge.
Your statements might be considered.
So the officer...
I can't guarantee I'm not them.
The officer further advised that the police believed Mathiason was involved in the burglary, and falsely, they told him that his fingerprints were found at the scene. They had not been, but they tell Mathiason, "Hey, man, we think you're involved in this burglary, and we got your fingerprints at the scene."
Since there was a parole, he had already been taken.
Yeah. So Mathiason sat there for a few minutes, and then he said, "Yeah, I took the property." So this occurred within 5 minutes of this dude showing up at the office.
And the officer detective's like, cha-ching.
Yes.
Got him.
Got him. So within 5 minutes, he says, yeah, I took the property. So then the officer puts a pause on things. He then advises Mathiason of his Miranda rights and took a full taped confession afterward.
All right.
At the end of the taped confession, the officer told Mathiason that he wasn't arresting him at that time. He was released to go about his job and return to his family.
Just indict him later.
Mm-hmm. The officer said he was referring the case to the district attorney to determine whether or not criminal charges were going to be brought.
Because Mathiason was so honest after a few minutes.
Yeah. So all in all, Mathiason shows up at like 5 p.m. He's out of the office at 5:30. So,
he's like,
in and out.
all right. See?
So at the trial, he moved to suppress the confession as the fruit of questioning by the police not preceded by the warnings required in Miranda.
Fruit of a poisonous warning. Or
That's
lack
a
thereof.
throwback. It's been several episodes.
I know. I haven't gotten it in there.
Oh, yeah. The trial court, however, refused to exclude the confession because it found that Mathiason was not in custody at the time of the confession. Yeah, conviction.
At the conviction, he probably wasn't.
He was definitely in custody.
Okay.
Then, yeah. But so they said, no, we're going to include your confession because you were not in custody at the time that you made that confession. So the Oregon...
We even read you your rights.
Yeah. The Oregon Court of Appeals affirmed his conviction, but on his petition for review in the Supreme Court of the state of Oregon, that court, by a divided vote, reversed the conviction.
Did anyone abstain from that vote?
No.
Okay.
It was found that although Mathiason has not been arrested or otherwise formally detained, the interrogation took place in a coercive environment of the sort to which Miranda was intended to apply. So the state appeals all the way up to the United States Supreme Court, and they grant
Certiorari.
certiorari. All right. So what do you think? What do you think about this case with what you know thus far? Do you think that the Oregon Court of Appeals got it right, or the Supreme Court of Oregon got it right?
This one's a little bit better because he actually reads him Miranda, and he told him he wasn't under arrest.
Mm-hmm.
So from my education background, it's would a reasonable person believe they were free to go?
Oh, man, that's a catchphrase and a half.
Uh,
You just summed up this hour and 30 minutes of cuffs and case law. So you're saying it's probably good to go?
it's a tough line there because I'm trying to think of the time period and how restrictive they would have been.
1977.
Yeah. If I had to make a decision, unlike the one Justice and Miranda,
Mm-hmm.
I would say they would have said that was good to go. They liked most of or all of that.
You're 100% right.
Great
Supreme Court
success.
said
They didn't lock a door or anything
Nope.
in terms of the context, and he also freaking released him.
exactly.
Not that that should matter to the first part of it, but
Shouldn't, but does. Yep. No, you hit the nail on the head, man. So the United States Supreme Court said, in the present case, there is no indication that the questioning took place in a context where Mathiason's freedom to depart was restricted in any way. He came voluntarily to the police station, where he was immediately informed that he was not under arrest. And then at the close of the half-hour interview, he did, in fact, leave the police station without any hindrance.
never had handcuffs on, nothing.
Nothing.
Never told
Nope.
he was under arrest, nothing.
Exactly. Supreme Court said
Or
it is
detained.
It is clear from these facts that Mathiason was not in custody or otherwise deprived of his freedom of action in any significant way. Such a non-custodial situation is not converted to one in which Miranda implies simply because a reviewing court concludes that even in the absence of any formal arrest or restraint of freedom of movement, the questioning took place in a coercive environment. So they're saying just because you talk to the dude at the police station does not trigger Miranda.
Yeah.
Right? It has to be in custody interrogation. And the facts of this case, they're like, there's no reason for us to consider that Mathiason was in custody. So they said, yep, this is good to go. Any interview of one suspected of a crime by a police officer will have coercive aspects to it, simply by the virtue that the police officer is part of the law enforcement system, right?
Adversary system, as you said last time.
Oh, man, it's an adversary system in which may ultimately cause the suspect to be charged with a crime, but police officers are not required to administer Miranda warnings to everyone whom they question. They reiterated that again. Nor is the requirement of warnings to be imposed simply because the questioning takes place in a station house or because the questioned person is the one whom the police suspect. So they thought it was him. It's at the police station, but they're like, no, he was not in custody. Miranda warnings are only required where there has been such a restriction on a person's freedom as to render him, quote, in custody. The officer's false statement about having discovered Mathiason's fingerprints at the scene was found by the Supreme Court of Oregon to be another circumstance contributing to the coercive environment, which made, in their minds, the Miranda rationale applicable. The Supreme Court said, whatever relevance this fact may have to other issues in the case, quote, it has nothing to do with whether Mathiason was in custody for purposes of the Miranda rule. So they're like,
Just because of what he said.
just because of what he said doesn't change the fact of he's not in custody.
Yeah. Because I guess no matter what evidence you're telling them, it wouldn't change your thought of being free to leave or not, is what they're getting at.
Yeah. And that's why it's important that they actually let him leave,
Yeah.
right? Because at no point in time did this ever become a custodial thing, right? So we'll get to that here in a different case. But if it starts non-custodial, but then becomes custodial at some point, well, now we're triggering Miranda. Spoiler
Yep.
alert.
But he covered himself.
He covered himself, start to finish, and
Once
the
the
Supreme Court
admission
said,
happened.
"Yep." Supreme Court says you're good to go.
I said, thank you for getting this right.
Yeah, they're like, it's about time.
We'll reward you with a conviction.
Yes,
That's the case, and that's the rule. If you'd like to see the full video breaking this topic down, make sure you click the video here. And make sure you subscribe for more nuts and bolts editions right here. Thanks for watching.